is somehow afraid of this because, well, I was not
Maybe we should
pushing,
speak
but
about
the
it.
idea of
I
this.
think it's important, maybe in the session that we'll speak about the ILO and why different governments do not go or do not go to challenge, because a lot of things that we heard here were against the decisions of the ILO Freedom of Association Committee.
Unions benefited the most from the ILO.
Okay.
Eventually, informally, because they. Yeah. Yeah.
This is,
Maybe the.
I would like,
Yeah,
who is, this is there?
Yes.
Who's sitting by you?
John.
Hmm?
John.
Okay, well, we need it. So we start, I want to start with our last session in which we are going to have two reports. But before, I just want to remind that what I have now in my list for tonight, just because the people do still want to join. I have Adriana and Tonya and Roberto and Nikita and Sylvain. So this is, and if somebody else wants to join, please let me know. And
Lost my mic. Lost my mic.
Sure. And I think what we were going to do now is speak about the report of, I think, now UK.
Yes. Oh, okay.
So you present your report and then Rachel.
We'll comment. Right. So I want to start with the simplest summary I can give you of the law in the UK, which is that there is a complete exclusion or ban on the police and the armed forces taking industrial action. And that's the easy bit. That applies to the whole of the UK. And the rest is fairly complicated. So I hope that you'll excuse me as I gradually go through this. So in writing this report, I realized that I couldn't write a UK report because the UK is made up of Great Britain and Northern Ireland. Northern Ireland does not have to adopt the statutes of the UK Parliament in Westminster relating to employment law. And most recently, the Northern Ireland legislature, which is in all sorts of difficulties, has decided for the time being not to adopt the Trade Union Act 2016. And this is significant because that legislation places particular restrictions on important public services. So I'm not talking about Northern Ireland. And then if we look at Great Britain is made up in terms of discrete jurisdictions of Scotland, Wales, and England. Now, Scotland does have to adopt any employment law adopted by the UK Parliament in Westminster, and therefore did have to apply the Trade Union Act 2016. But being run by the Scottish National Party, the Scottish National Party decided to try to defeat the application of the Trade Union Act 2016 and resist it by deciding that it would create a £250,000 fund to assist trade unions in resisting the act. So that was subversive. In Wales, the Welsh Parliament adopted the Trade Union Wales Act of 2017. And although Wales is supposed to enforce Westminster employment law, they have discretion over their own public services. So in Wales, they decided that the restrictions on important public services in the Trade Union Act would not apply to Wales because they have control of their own issues around border control, transport, education, and hospitals, and therefore we're not going to be bound by the legislation. So I'm, for the rest of this, just talking about England. Right, okay. And the way in which English law restricts industrial action in essential services is not by any overarching legislative restriction of essential services per se, or the kind of apparatus that we see in Australia with the Fair Work Act, but in a very odd dynamic relationship between the common law, which is well established in England, and statutory provisions which provide immunity from action in tort and dismissal under a Comprehensive Trade Union Labour Relations Consolidation Act. So there's this interesting interaction between common law and statute. Under common law, any industrial action is a breach of contract, usually, either because it's the breach of the express term to work or the implied term of fidelity and mutual trust and confidence. We do not suspend industrial action, the contract during industrial action. It is a breach, and at common law, the employer has the discretion to dismiss. So there's that residual power. The second point is that the trade union or any entity or person can be found liable in tort for calling industrial action, because they could be inducing a breach of contract, either directly or indirectly. They can be involved in a civil conspiracy. It can be seen as a form of economic duress. And this is where essential services enter the picture. There can also be a tort of breach of statutory duty. To the extent that a statute sets out a statutory duty with a clear class of claimants, then it is possible to bring a civil action for breach of statutory duty. And that would affect, for example, telecommunications, water, electricity. Many of the services previously provided by the state or local authorities, which have since been privatized. So covered within that as well would be the regulation of prison officers and others. So we have this common law system, and then we have statute, which provides certain limited protections from dismissal and from liability under tort. And maybe it's easiest to deal with the protections from dismissal first. So if you take part in industrial action, and no one taking part in industrial action is a member of the union, then it's called official industrial action. You don't need a union to authorize that. We have our own ability to take these kind of wildcat strikes. And when that occurs, those who participate can be protected from what we call selective dismissal. So if everyone in this room takes part in a strike and none of us is a member of a union, then we are protected because the employer has to dismiss all of us or none of us. And if they dismiss all of us, they can't selectively rehire within a 3-month period after the end of the strike. So that's protected.
But they cannot hire immediately, as was suggested yesterday.
Well, no, the employer could rehire everyone immediately, just can't selectively rehire. If one of the people around this table was the member of a union, then the union has to call the industrial action in order to get that protection from selective dismissal. And for the union to call that action, they have to be pretty clear that they won't be found liable in tort. And that means that the union has to follow certain requirements relating to the nature of the trade dispute. It has to be for certain legitimate purposes, and also has to follow certain balloting and notice requirements that I'll come back to. So essentially, the protections from dismissal, if there's any union membership involved, the protection from selective dismissal relies on union authorization, which will turn on whether the union thinks that it's going to be okay to authorize the action. There's also a further protection, which is from, which we call protection from dismissal or protected action, which is where the trade union can demonstrate that it is a lawful trade dispute in terms of its substance. It has followed all the balloting and notice requirements. And then you get protection from dismissal just for 12 weeks. But after 12 weeks, you get no protection unless you can demonstrate the employer's behaved very badly. So that's how our protection from dismissal works. It's normally contingent on the trade union acting and acting responsibly. There are restrictions on what is a lawful trade dispute, and this has to be a dispute between workers and their employer. It has to be wholly or mainly about certain matters, which are usually about terms and conditions and so on within the workplace. There is no substantive limitation around essential services. You know, it doesn't make any difference that this might affect essential or public services. The balloting or notice requirements, however, have been changed by the Trade Union Act 2016 so that there are additional requirements when certain important public services are involved. And those important public services are some of the things that you might expect. So the fire service, for example, and water security, and also hospitals, but only state-funded hospitals, and only in certain areas where there really is a risk to human life and health. So, for example, an accident and emergency, that's an important public service. But then you get to education, which is regarded as an important public service, just generally. Teachers in any non-fee paying school, any state school are covered, and that goes against ILO standards, which doesn't see this as connected to life, human health, safety, and the public emanations of the state. And then we have transport, which is far-reaching. So London bus services, bizarrely, but not other bus services, passenger transport, and also ports and airport security, interestingly enough, but not airlines. So we have a set of regulations which elaborate on this. And what it does is it changes our balloting requirements. So we have very elaborate requirements around balloting and notice that I'm not going to go into in detail that apply to all industrial action. They're so extensive and detailed in that paper. I gave you a long paper to read. But those are restrictive and chilling as they are. But what the Trade Union Act 2016 did is it said you don't just need a majority in the ballot of the trade union members eligible to vote, who turn up to vote on the day. You need to have a 50% turnout, which is a bit like the Australian system, I think.
And also electronic.
And for important public services, 40% of those eligible to vote have to have voted in favour. So you have these three criteria working together. And what this does is effectively, in combination, makes it very difficult to take industrial action in the important public services. The other point is that statutory immunity relates to certain torts, but it doesn't cover the tort of breach of statutory duty. So if you are taking industrial action, for example, in the telecommunications or the water sector, you could potentially, as a trade union calling the industrial action, be liable in damages, and an injunction could be sought by the employer to stop you from taking that action. So the way in which the things dovetail is the tort of breach of statutory duty isn't covered by the statutory immunities, never has been. We don't have any case law on it. It just has this ongoing chilling effect in terms of strikes in that area. And then we have this new provision about important public services that makes it very difficult to achieve the 40% support threshold of those eligible to vote in the ballot. There is no compensatory system as the ILO would understand it We do have a system whereby, for example, in the prison service, you have pay review bodies, and that will make recommendations to Parliament at the level as to the level at which the pay should be set. But if the government doesn't implement that, then we have recent case law which demonstrates that prison officers are still unable to strike. So there's no expectation of compensatory guarantees. We also know that the 50% threshold was probably aimed at strikes in public services. This is the 50% turnout threshold. That's going to be more effective in terms of preventing effective ballots than anything else in the public sector. I should say just a few words about how liability is limited. So the Trade Union and Labour Relations Consolidation Act doesn't just provide immunity in relation to the statutory torts, it provides a statutory cap on damages, which goes up to £250,000 in respect of a strike, depending on the size of the trade union concerned. So if it's a very small trade union, actually you could pay only, say, £10,000 in damages, even though you cause considerable disruption. But because employers know that there is this cap on liability and damages, they tend not to wait for the industrial action to happen and then to sue and tort. What they do is they seek preemptive injunctive relief. And they do that under principles that we call the American cyanamid principles, which means that they need to show that they have a prima facie case, which could be that there is a tort of breach of statutory duty, or it could be that the balloting requirements haven't been formally met. And then they just need to show that they have that potential case and that the balance of convenience is in the employer's favour. And normally the employer can show that because they're likely to suffer considerable economic harm in the face of a strike. So what we've had to date is a lot of cases in which the courts are unsympathetic to the trade unions and issue the injunctive relief that the employers request. So because all you need is the prima facie case and the balance of convenience, you don't need to necessarily prove your case at trial. And this again has a massive chilling effect. It's at this point that I should stress that there is no constitutional protection of the right to strike in the UK. We have a partially written constitution that consists of various declaratory and statutory instruments and common law principles. None of these protect a right to strike. The closest thing that we have is the Human Rights Act, which includes certain convention rights within the jurisdiction of the UK, including Article 11 of the convention, which has some flow-on effects for protection of the right to strike. Very recently, back in 2012, we finally had a statement in a case involving RMT, our Rail and Maritime and Transport Workers Union, that you have to interpret the trade union legislation in light of the right to strike, which means that you should be paying attention to Section 221, which means when you issue injunctive relief, you should be thinking about the likelihood of the case at the trial. It also means that you shouldn't construe the notice and balloting requirements strictly against the trade union. But even Lord Justice Elias, who presided in that case, said, recognising a right to strike does not mean that the right to strike takes precedence. It just means that you balance the interests of the employer and the trade union when assessing injunctive relief. Recently, it hasn't made that much difference. We now have a much more stringent ballot paper, which means you have to set out the reasons for the dispute much more clearly than you did previously. And we have quite a sympathetic hearing of that in Thomas Cook Airlines, in which they said, well, actually, the designation of how the industrial action would take place was sufficient for the purposes of the new Trade Union Act 2016 requirements. But we also have another case which is related to the Royal Mail. And the Royal Mail has this legacy of certain constraints on industrial action. In that scenario, they said that a collective agreement which indicated that the dispute should go to mediation and arbitration before industrial action could take place had to be honoured, that it was legally binding. That's very unusual in the UK, that you ever find a collective agreement to be legally binding. In the context of the BA disputes, they found that the collective agreements were not legally binding on BA. But in the context of this, they said that it did bind the union and they had to go to mediation arbitration. Again, this was just a court case in 2017. So we're not finding uniform sympathy for trade unions. And together, the common law and the statutory provisions have this quite profound chilling effect alongside the procedures for injunctive relief. And that's basically how it works in the UK.
Good job.
Okay, well, thank you, Tonya, for a very comprehensive, detailed picture of the law relating to industrial action in the UK, or for the most part in England,
Yes.
not Scotland or Wales. And I think you've done very well for what is a very complicated situation. So thank you for that. Like Australia, I guess, the essential premise is that the system operates pretty much by way of a system of immunity from actions in tort and breach of contract litigation, at least where certain conditions are met. And then you have the statutory situation where, by virtue of a secret ballot process being set up, then it's hard for, or the process of strike action may be possible, or a lawful trade dispute may be possible in the UK, and protected industrial action may be possible in Australia. So the situation is familiar to some extent to me. What I was going to say, a couple of things. You say at the end of your paper that the law relating to the treatment of strikes in essential circumstances in the UK is, quote unquote, remarkably complex. And my comment or my thought on reading the paper was, just how complex should the law in this area be? And in doing a little bit of reading about the area for my own paper and on reading yours, I look back over one of my colleagues, Shay McChrystal, who you and Eric know quite well, but something she wrote about the Australian system, and she quoted from Deakin and Morris's text and your article from Australian Journal of Labour Law article, which are both quoted in your bibliography. Well, she was writing and she cited those articles. But Shay's point was that the ILO standards contemplate that prerequisites such as compulsory ballots for taking industrial action may be acceptable, but only so long as they are reasonable and not to place a substantial limitation on the means of action open to trade union organisations. And maybe that's something you've obviously said it before, that it belongs in this kind of area as well, I think. You talk in the paper about the new law of 2016 dealing with important public services. And when I read the paper, it seemed like you explained it more this morning, that there almost seems like a slippage in language from the words essential service to important public services. And I was wondering, at the time when the legislation went through, was there any argument in debate about that sort of issue? Because that's clearly an issue in Australia, as to the nature of the way that. So maybe that's something that could be the extension of what we mean by definition. I won't say much more, but I noticed that just before you started talking, that a couple of people were talking about complaints to the Committee of Experts of the Committee on Freedom of Association about various legislation. But does that happen under UK legislation on some of these points? Because it's not an uncommon issue in Australia. And has it happened in relation to any of the legislative points you've raised? Because again, I think this is maybe something that would belong in relation to some of the points that you raised in your paper.
The answer is yes. That there was considerable debate about the idea of important public services as a slippage from essential services. You're right, I did write on that with Michael Ford and with Ruth Dukes and Alan as well. It is buried in the paper, but it's a hell of a long paper, I'm sorry. It's on page 20 of the paper. So what happened at the time that we were proposing the UK government was proposing the legislation, and a lot of us were lobbying about this, and there were quite intense parliamentary debates in committee stage around drafting and other ways. This went to the ILO Committee of Experts on the application of conventions and recommendations. And even though there was so much pressure on that ILO committee at that time not to talk about strikes, they did. And what was interesting about it is that they didn't see that there was a problem with the 40% requirement of approval from those within the bargaining unit, which is really interesting because they reinterpreted what they said previously and suggested that this was potentially okay. So they didn't make a fuss about that. Or the 50% turnout, which struck me as really interesting because we had lobbied about that being a problem. Instead, they said that it was just wrong to place additional constraints arbitrarily on certain important public services, particularly transport and education, which fits with the ILO case law.
Because it's like full in there, because if you remember, it's not in the first tier of essential services, it's in the second.
It's in the second, so you have to justify that there is, either you're dealing with some imminent state that matters, or you have to demonstrate this threat to life, health and safety. So in that context, it was condemned by the ILO committee in advance of the legislation being adopted by Parliament. And the compliance looked at this, highlighted this as a potential problem, and the government wrote a letter explaining why this wasn't a problem at all. That ILO standards are not formally binding in terms of domestic law in the UK because it's a dualist and not a monist system, and therefore they thought that ILO was mistaken. They didn't have a problem with it. They didn't raise the kinds of issues which Adriana's raised about other competing constitutional or human rights, which, they possibly could have done, actually. But I think that the UK Conservative government is hostile to human rights as well as a liberal rights approach, so they weren't going to do that either. And how complex should the law be? I think the ILO has said at various stages that UK law is too complex, and so is the European Committee of Social Rights on a variety of matters. So we don't just give notice of industrial action, we give notice that there will be a ballot of industrial action. We give the ballot paper to the employer in advance, and we now have to give 2 weeks notice of any industrial action. So, you know, we have very stringent requirements for industrial action. And when I think about how complex should the law in this area be, I think it's pretty sly to combine these forms of common law liability with complex forms of statutory immunity in this way, and then to relayer that with important public services. I would almost much rather have something like the Australian system where you simply identify what are the essential services which are potentially a concern, and you address those head on. I think it would be more honest somehow.
May I ask you something?
Mm.
Just in order to understand better. How common are actions by users, consumers, against unions or enterprises in order to get damages for what they suffer in the occasion of strike? Because we were talking about liabilities, but I understand the relationship is between the employer and employees when we were talking about it. So my interest is focused on the third parties, the victims of the strike. Marty was talking about the boy that drowned during the action, and our perspective, as you understood, is very much the Italian one, based on what the user consumer suffered during the action. So how this perspective is treated under the English law?
Yeah, right. So this was a concern of the Conservative government under Margaret Thatcher from 1979 onwards. And what she did by the mid-1980s was introduce 2 commissions that would deal with this problem. One was called the CRTUM, or it came to be known colloquially as Croton, which was which was about the Commission for the Rights of Trade Union Members. So if trade union members thought that their union was taking industrial action the way they didn't like, they could go for commission. The commission would help them sue their trade union. And the other one was Sequoia, which was for the protection, essentially, of those who were taking action against unions and industrial action. So those would be your third-party consumers and clients. The Commission did assist about 6 or 7 cases over about a 15-year period. So members of the public were not that interested in bringing these claims, no. Mainly because industrial action rapidly dropped off. So it is now 1% of what it was in the mid-1980s. And what tends to happen is that, as we were talking informally before about how trade unions work with employers during, say, industrial action on the railways, so they won't charge consumers for their travel during the days of the strike. Mm-hmm. And the unions won't man the ticket boxes and the employers won't charge. In quite exceptional circumstances, you might find somebody who is disadvantaged. Mm-hmm. But on the whole, we tend to find that consumers are just not that activist around their rights. And recently there was a case that tried to use EU law on free movement to try to close down a strike by ASLEF relating to driver-only operated trains on the Gatwick service. And the idea was this would protect, interfere with people's free movement. It was argued by the employer. And in the end, the court just turned that down and said minor inconvenience during the strikes over 3 weeks. There are alternative routes, it's a reduced service. It wasn't a claim for compensation, it was a claim for injunctive relief on the basis of EU law, and they wouldn't grant it. So we don't have a tradition. Margaret Thatcher did try to create a tradition, to provide state support for these sorts of actions, but they never really materialised.
Monica?
I was always curious about this ballot system because I mean, I can clearly see that the combination of these factors may cause an additional problem. But now, when I turn to our own system, where we do not have a legal ballot requirement, but it is usually taken in the bylaws of the unions. But there, the threshold is much higher. It is something between 70 and 80%, and that is not a problem at all for the unions to reach that, because otherwise...
70% 80 majority or 70-80% quorum?
Well, now I'm not sure what you mean.
No, what they mean.
So you could have a 40% turnout in the ballot and still have 90% in favour, which sometimes happens actually in the context of our university and college union. We get those kinds of results. We have to get, for the new industrial action that's being contemplated at the moment, we have to get over 50%, and we don't need to worry about 40% of those eligible to vote because higher education isn't covered, but we will need to get a majority as well as that. What came up in the context of these debates were debates around electronic balloting. So what my union does is it does a pre-ballot ballot by the web and tends to get about 70 to 80% response rate and response on industrial action. And then we'll go to the employer with that as a way of trying to stop any industrial action taking place as a bargaining tool. And if that doesn't work, we'll then hold the ballot, but the numbers are always much lower in our system because it's only a postal ballot and it gets sent to the workplace. And that creates forms of difficulty. It's, if there are over 50 employees, then it's run by an independent scrutineer. So it's a very fair procedure, but it's complicated. So we argued for electronic balloting, and there is going to be a trial of electronic balloting apparently, but it hasn't been placed in practice yet.
Monica said that in Germany it's required by bylaw, and the unions in Germany have no problem with the balloting. Is what I understand.
Yeah, that is the point. Obviously, I mean, the unions would not try to call a strike if they were not really sure that it is supported by their own members, almost by everyone, and so the requirements are usually met. And then if people already say, well, this we don't want to have this situation anymore, then they are really engaged enough to actually show up. Mm-hmm. So we do not have this electronic, well, if they can do, as it is in bylaws, they can decide to have it. But if they don't have it, at least to my knowledge, it has not been a major problem. So something must be different here, and I'm not quite sure what that was.
Yeah, so I mean, does the ballot, because the British trade unions, a lot of them have had these bylaws, and that was the reason they were introduced in law, was they had the bylaws, and some of the trade unions, for example, in the context of the miners' strike, weren't following their own bylaws when calling the industrial action.
Yeah.
But do you have a threshold? Do you need to have 50% turnout? Or is it just on the number of people who feel strongly about the action? Because if it's about the number of people who feel strongly about the action, that's relatively easy. The turnout requirement is the one that research suggests is going to be really difficult for us.
It's quorum.
Speaking of Margaret Thatcher, I almost go with him. Do you, the miners' strike of 81 seems, at least to an outsider, like it was a watershed moment in labor relations and strikes.
That they are controllers in.
Like yes. Your perspective too, or just maybe to ask as a question, what effect on the development of the law do you think the miners' strike had?
I think it had a tremendous effect. I think, but also it wasn't just the miners' strike, it was the winter of discontent that preceded Margaret Thatcher coming to power, and the idea that you had to tame trade unions. So this is what happens in a collective laissez-faire system where the trade unions are not seen to act responsibly and to get everyone wet. And there was that massive backlash. And we haven't really got through that. So even when we had a new Labour government, they kept the architecture of the Thatcher regime in place and just modified it a little bit around the edges. So a lot of the disputes around balloting are not necessarily that you don't get a majority or even a significant majority, they're that you didn't give the notice of the result within 48 hours. It's, 48 hours was too late, it had to be within 24 hours, even though it doesn't say that in the legislation. Or it's that certain people who were eligible to vote never got the ballot papers, even though they didn't come forward, that's enough to invalidate the ballot. And what happened is the new Labour government tweaked that a little bit so that if a negligible number of people don't get the ballot paper and it's not statistically significant, it doesn't affect the result of the ballot. But it's very, it's a very technical process. It's a way of trying to defeat access to industrial action in this way.
I have some questions. First of all, I remember that during the Olympic Games in London, they used the army to replace the border control workers. And can you say something about the use of army to replace strikers in essential services? Because usually the UK situation or the Great Britain is always cited as an example. Also, it happened in the States and some other places, but still.
I checked that because you raised it in the meeting in Trier, and actually, although the Civil Contingencies Act, which replaced our Emergency Powers Act, was utilised during the Olympic Games, it wasn't utilised in the context of any industrial dispute. So what occurred was that the rail, the tube and the bus unions all went on strike in advance of the Games and threatened to go on strike at the time in order to negotiate bonuses for the extra work that they would have to do during the Olympic Games. And it was a tough process of bargaining, and ACAS was involved, and there was industrial action. But they did get the bonuses. The RMT did the best. But at the same time, what the Civil Contingencies Act does is it enables you to draft in members of the military and the police to carry out certain functions, but it hasn't yet been used for replacement of strikers. Now, the Emergency Powers Act was used in relation to a miners' strike back in 1972, and there were special emergency regulations created in respect of the miners' strike and policing regulations. But we haven't used the Civil Contingencies Act in that way. I think it would be seen as inflammatory. So it is true that when the fire services went on strike and had a minimum service, the army was on call as a backup, but that was also agreed with the FBU. So I don't think it operates in such a problematic way in practice. At least this is talking to people in the TUC and also just checking the established texts in the area, people who research in it. So Anne Davies and Simon Deacon and Gillian Morris. And Gillian Morris is the leading authority on public sector strikes.
And if you speak about Gillian Morris, he wrote some years ago that the legislator in the UK don't need to regulate striking essential services because they can rely instead on the tort, as you spoke about. And the question is, how many cases you have really, I think it's related to what Adriana asked, what is really the real experience? So it's just the theoretical threat that it may cause a tort act, it may bring about a tort action, or whether you really have cases where unions and employees were brought to trial in a tort action regarding strikes in essential services.
We have no such cases. It has a chilling effect. So people do not take action generally in telecommunications or in water or in power. They don't do it because they are also under statutory duties. And I think it has a chilling effect, but we don't have any case law.
So we don't have such a severe approach to the strike, and we had two cases. It's interesting and new for so many years. This your tradition of kind of anti-union on the part of the judiciary haven't had any cases.
No, but also, I mean, I wonder if it's about the effects of privatization too. So our unionization in the private sector is less than 14%. And if you think about what happened when these services were privatized, the union membership just was decimated. So the idea that you're going to have effective strikes in those areas and the types of contracts under which people hired makes it very unlikely that they would be taking that action. We have had much more spontaneous action in quite exploitative shop work, service work situations, of cleaners, of serving staff in McDonald's and so on, which have been much more spontaneous forms of industrial action and actually haven't involved trade unions. But these are just reported in the press. They're not subject to legal case.
So may I ask you, recently there was the junior doctor
Yes.
action. I'm not sure I got how the dispute was settled, because it seems to me the doctors lose the battle.
They did.
Lost the battle.
They did.
And I don't understand how the government managed to silence this protest and stop it. It was a huge problem.
It was, yeah. So it was a long-running dispute.
It's
Yeah.
in the paper.
It is in the paper. But you don't get to see
Yeah.
it. But I'm very happy to talk about it briefly. So basically, the strike that took place in 2016 in the English National Health Service by junior doctors led to the loss of 129,000 working days. So it was the most significant public sector action. What happened was that Jeremy Hunt, who was Secretary of State for Health, wanted to unilaterally change the way in which the National Health Service delivered care. And he wanted to create a 7-day working week so that there would be no bonuses for working over the weekends for staff, which has certain indirectly discriminatory effects for working parents, in particular for mothers. So he tried to impose these contracts, which involved 12-hour shifts, which would be spread over the 7 days. It amounted to approximately a 13% reduction in pay for junior doctors, but more than that, it affected the quality of their living and working lives and their ability to get compensation, to get care at the weekends, which in the UK, I don't know about other countries, is almost impossible for children. And there was a fierce reaction, which was about the quality of care, that the shifts were too long, that the way in which this would work was not going to provide appropriate apportionment of senior to junior staff. And the British Medical Association called a strike, so that these contracts wouldn't be unilaterally imposed. They did unilaterally impose these through trial in 3 different areas of England, and they were not a success. So there was a lot of sympathy for the doctors, and they held 1-day strikes from time to time. But at the point when they said that they were going to start doing week-long stoppages with minimum service, the doctors got cold feet. They were very lucky that no one seemed to die by reason of the strike. There were no deaths on the days of the strike. And they were worried that their political luck and leverage would run out in terms of a strike. So trying to avoid that third-party problem, and unions have to maintain that popularity and double action to work concessions and around flexibility for working parents and some other bits and pieces, and backed away from it. The contracts have been imposed, and it's gone ahead. So it was an attempt to stop the changes within the NHS. And what has happened as a result of that is that you have more NHS indirect funding of private healthcare now within the UK, so contracting out of key operations. You have more staff who are employed on an agency basis as a result of this, and the core staff are on these 12-hour shifts. It wasn't great for the health service, but it wasn't a battle that ultimately the doctors could win politically.
Okay, thank you.
Okay, thanks. So, can we come to the last one? Joe, United States.
So I am conscious of the fact that this entire session should have ended almost a half an hour ago, so are we okay for time?
No, we are okay for
All right.
time.
Okay.
We have some time for discussion at the end. It's okay.
Okay, thank you.
Take your time. It's very important because you have such a very, very complex and interesting.
Yeah,
Wait.
complex, interesting. I am conscious of being the last person before all the fun begins today. I realized that I would have been the first, Richard, if I had been listed as America.
I would have.
But yes, I know that Canadians tend to be sensitive about that. Yes. But since my fellow North American is commenting on my paper, I don't want him to be mad at me. Also, since I'm going last, I think I am confident that I speak for everyone in wanting to thank Moti and Lily and the other organizers for doing such a great job putting this together and dealing with all sorts of complicated logistics about getting people here and there. So thank you for an excellent. Okay, so the United States. To understand the strike rights of employees in the United States, you have to understand that this does not map onto the ILO or models of other countries particularly at all. The U.S. law does not define essential employees at all in any of its labor relations statutes or decisions. It does not even pretend to comply with ILO standards, and in some senses it may proudly be in violation of ILO standards. Strike rights and union rights in general in the US are much better understood by the dichotomy of whether you are a public employee or a private employee. And in short, if you are a private employee, you will be covered by a federal statute, which is standardized. You are likely to have what exists, at least on paper, as fairly robust strike rights, although, as I will discuss, and on the ground, these rights are not so robust. If you are a public employee, on the other hand, you are governed by either a state or local law. Each one of the 50 states in the US has at least one public sector labor statute, and in fact, many states in the US have more than one that govern different employees. There are, in fact, over 100 different public sector labor law statutes in the US that give quite different rights to employees. So to begin alphabetically, Alaska. No, I don't have quite enough time to do that. So I will summarize, obviously, the major approaches of the countries, but also by way of introduction, although statistics are not thorough in the public sector, it is clear that, as with Canada, strike rates in both the private and public sector have plummeted over the last several decades, and I'll offer some speculations why later. So I am first going to talk about the private sector, because there is no definition of essential employees, and I know that from hearing all of your papers that there are definitions of essential employees that vary. It is very possible that some people that would be considered essential employees, at least in some countries, in transportations and utilities and hospitals, for example, and food delivery, would be in the private sector. Private sector, you are likely to be covered by the major labor statute in the private sector for the US, the National Labor Relations Act, or NLRA. The NLRA on paper, again, gives fairly robust strike rights. It is a protected right under the National Labor Relations Act. Indeed, Section 13 of the NLRA says that the NLRA should not be interpreted either to interfere with or impede or diminish in any way the right to strike or to affect limitations or qualifications on that right, which sounds like a pretty robust right. But we will see that it is not so. And on a day-to-day basis, the most substantial restriction on strikes for private sector employees in the US are no strike clauses in actual collective bargaining agreements, which are ubiquitous. Almost, I mean, I've never seen a private sector labor contract in the US that does not have a clause in the contract that prohibits strikes or lockouts. So there are other types of restrictions in the law against strikes, like some of the other countries, but not all of your countries. The US has a fairly strict ban on secondary actions, which is enforceable by injunctions and tort-style damages. We have in the US in the private sector and in the public sector limitations on partial strikes. One of the things that has intrigued me the most about learning about this controlled strike model, where some people can go out and other people have to stay behind, is that would be considered anathema in the US. It would be clearly illegal as a partial strike. And sit-down strikes are also illegal in the US, and strikes involving violence or other types of illegal activity are illegal in the US. But the most substantial restriction on strikes in legally speaking is the existence of no strike, no lockout clauses in contracts themselves. So why have rates been declining so much? Well, the theory of many American labor scholars, and I have to maybe reconsider this in the light of what Eric said about Canada lately, is, and this I will take you back a little bit in history now in the private sector. Back in the 1930s, soon after the National Labor Relations Act was passed, there was decided a case in the US called McKay Radio. And what McKay Radio said was that employers could use permanent replacements for economic strikers. What do we mean by an economic striker? Well, an economic striker is someone who is striking. The primary motivation of the strike is wages, hours, or working conditions. The distinction is with unions who are striking over the employer's unfair labor practices, the employer's violation of labor law itself, an employer that won't bargain with the union, for example. But most strikes, not surprisingly, are not over unfair labor practices, they're over economic conditions. And if you are striking for economic reasons, then you can be permanently replaced. So what does it mean to be permanently replaced? Well, the replacement is hired during the course of the strike. It can be kept on after the strike ends. It's not exactly the same thing as being fired, because the employee has a right to get his or her job back if and when the job becomes open. So if a replacement leaves the job, then the employee can come back and take that job. But as common sense would dictate, for the vast majority of employees and the vast majority of strikes, the replacements stay. So in effect, economic strikers in most cases will be effectively fired, or can be effectively fired by the employer. The employer is not required to use permanent replacements, but they often do. Interestingly, historically, this was not a common practice among US employers until around the 1980s, when also PATCO happened. But with the 1980s and Ronald Reagan, our Margaret Thatcher, except dumber, came, and there was an anti-union wave, and employers started to use permanent replacements later. So I think one of the primary effects of this has been that with employers using permanent replacements aggressively is that the private sector unions have been largely cowed. There have been much fewer strikes, a much lower success rate of strikes in the private sector. So again, on paper, these, many people that could be plausibly described as being in the essential services, if they work in the private sector, have strong strike rights. Really, the only limitation is a minor procedural limitation. If you are in a private hospital, you can strike only after you give 10 days notice you're going to strike. But all other unions, utility workers and other types of transportation workers, can strike fairly frequently, assuming there's no contractual bar to it. But on the ground, they don't, because I believe in large part because of the threat of being permanently replaced. And that is where we are in the private sector. So there has been no big examples of essential workers in the private sector striking that I can think of in decades. So now to the public sector. So most of the employees that would at least intuitively be described as essential employees work in the public sector: police, fire, prison guards, ambulances, many, if not all, hospitals, arguably a good set of schools. So in the US, again, the labor laws vary state to state, and often even within the same state vary employee to employee. And there is some concept of essential services lurking in the background, because there is no state, for example, in the US, where police or fire or prison guards can legally strike. However, I think more frequently the rules for these essential employees in the public service are subsumed by broader rules that cover all public employees in states. So I'm going to speak briefly about models in the US of public sector labor laws. So there are basically 4 models. There are some states, about 9 states, in which public sector employees, period, none, can, not only can they not strike, but they have no right to bargain collectively. And there's even a couple of states where the prohibition on bargaining collectively extends even if the employer wants to. For example, Virginia and North Carolina both have the rule that, because in some states where collective bargaining is not authorized by statutes, sometimes employers will still deal with unions, again, law in action and not law on the books. So in some states where collective bargaining is not authorized, it still goes on in an informal and weakened sense. But in some states, you can't even do it if both sides want to. So one model, about 9 states, collective bargaining is not authorized and sometimes not even permitted, much less strikes being permitted. In a plurality of states, about 32, 33 states, is the model where you have collective bargaining is permitted for public employees, at least some public employees, but strikes are not allowed for any public employees. And then there are states within that model that give collective bargaining rights to some discrete groups of public employees, but not other groups of public employees. For example, there are states in the South that only give collective bargaining rights to police or firefighters, but nobody else. And then there are states which allow, and there's about 11 states, including, I am somewhat proud to say, the state I'm from, Ohio. There are states in the US, about 11 of them, that permit collective bargaining and at least some public employees to strike. Again, never police or fire, but some public employees. So, for example, a union of hospital workers in the public sector in Ohio could legally strike, with some restrictions, which I will get to soon. So one question about this, and this is just a little more history and context. One question about this is why did it turn out this way in the US with public sector rights so different than private sector rights? And as we've seen there, this is not entirely uncommon, but I think it's worth pointing out, and I will say parenthetically that I wrote an entire historical monograph on the development of public sector labor law, but I will only tell you one incident from that history today because it's relevant. One of the central events in, I think, limiting the public sector rights of unions in the US was a strike of essential employees, and specifically a police strike in Boston in 1919. There was a major police strike in Boston in 1919, interestingly, over the issue of whether the police could affiliate with the American Federation of Labor, which was the big group in the AFL, the predecessor of the AFL's CIO, which is today our umbrella organization for labor unions. The police in Boston, to make a long story semi-short, wanted to join the AFL. The police commissioner said, no, police have to be neutral in labor disputes, meaning we need police to bust heads in strikes. They insisted on affiliating with the AFL. There was a big strike in Boston. It was fairly disastrous. There was lawlessness in the streets for several days. A number of people were killed, maybe by strikers, maybe by criminals, maybe by the state militia that was called in to do it. But this had a long, to quash the strike, this had a long-lasting effect on U.S. labor law. In fact, in the Patco strike, which was probably the last significant strike, and this is, I shouldn't abbreviate, the Professional Air Traffic Controllers, a federal employees union in 1981 went on strike, probably the last significant strike of essential employees in the U.S. It was crushed by Ronald Reagan, fired all the strikers, took all sorts of other actions against the strikers, including bringing successful criminal charges against them. The statute that governs employees of the federal government not only makes strikes illegal, but makes striking a crime. But relevant to the Boston police strike, Ronald Reagan, when he was doing this crushing of the Patco strike, cited the Boston police strike as a model, and he was following in the footsteps of Calvin Coolidge, who was then the governor of Massachusetts, who crushed the strike. And there have been other references to the Boston police strike throughout U.S. history, throughout the 20th century, even in terms of discussing whether public sector unions should have collective bargaining rights, much less rights to strike, because after the Boston police strike, public sector unions in the U.S. said, okay, we give up the right to strike, we just want the right to collectively bargain. The response to all that was, well, if you let public sector unions bargain, they're eventually going to strike. If they strike, it'll be like Boston. So nobody, not even street sweepers in Baltimore, can have just collective bargaining rights, because we all know where that leads to, at least to the Boston police strike. So that was a very central event in the U.S. So nowadays, again, we have these different models of strikes. And again, in some instances, public employees can't even collectively bargain. I mentioned in my paper that some unions made a complaint to the ILO about North Carolina's prohibition on collective bargaining, and the ILO found that that was a violation of ILO rules. But of course, the U.S. is not a signatory to their relevant rules, and you will be shocked to hear that in the 10 years since that decision by the ILO, North Carolina has not changed its policy on unions at all. So these employees, they have no strike rights, and this is what I really want to stress. They have no alternative methods. There's no, what other people have been calling, compensatory measures. They have no arbitration. They have literally nothing. So this would be obviously in violation of ILO rules. So if you are a public school teacher or janitor, much less a policeman or firefighter, in these 9 or so states, North Carolina, Virginia, South Carolina, etc., you have no rights to strike, you have no right to collectively bargain, and you have no alternatives or analogs. So that's sad for them. The next, I did not mean that as a joke. The next group of employees are employees who have rights to bargain collectively, but they have no right to strike, and they have alternatives, but they are not entirely robust alternatives. So there are some states in which, for example, the union has a right to collectively bargain, or certain groups of public employees have a right to collectively bargain. And if they come to an impasse, maybe there will be mediation, and that's it, which of course is non-binding. Maybe there will be a process by which a party, usually a private party, sometimes a government agent, will investigate relevant facts, some of the same criteria that Eric was talking about for Canada: how much are similar employees paid, what is the budget of the local government, etc. And the fact finder will make recommendations, and perhaps those recommendations will be made public, which could be used to try to bring political pressure on the employer. And that, in fact, is the point. Usually these laws say something like, well, if you agree with the fact finders for the recommendations, they're never made public. But if you disagree, then they become made public. But at the end of the day, it is not binding on the employer, and the employer can simply say no. Then there are employees in some states, in some jurisdictions, who have a more robust alternative, who have, and this is probably, again, the plurality model, the most common model, although not a majority. And in this majority, the employees can't strike, but if they come to impasse, they will go through typically mediation and then some form of fact finding and then some form of arbitration, which is usually but not always binding. Again, there's so many oddball variations to this. And there's different ways that the arbitration could work. And my paper gets into things like, you know, can the arbitrator split the baby, or does the arbitrator have to take one of the final proposals of either side? All those variations exist. And so within, for example, my state, most public employees have the right to strike after they have gone through mediation and fact finding. And they can, if that has not been successful, they can strike. But police officers, prison guards, firefighters, they have no right to strike. If fact finding does not work for them, they go directly to interest arbitration, which is final and binding. So it seems like at least some places in the US, there are either strike rights or a robust alternative to strike rights, if you consider binding arbitration a robust alternative. And I know that there's debates about that. But one more caveat to this. Even in jurisdictions where public employees are permitted to strike, there are typically many more hoops that you have to jump through. So I will give you just one example from my state of Ohio. So I said, hey, in Ohio, let's say if you're a school teacher or say a member of a faculty union like I expect to be in a few months, you can strike if mediation and fact-finding fail. That sounds okay. But here is the catch. The catch is that for fact-finding to fail, the fact-finder's report must be rejected by a 2/3 majority of one side or another. And following up on something that Tanya was talking about, or asking a question, what do we mean by 2/3 of the party? Well, under Ohio law, for a union to reject a fact-finder's proposal, it has to be rejected by 2/3 of all the members of the union bargaining unit, not 2/3 of all those voting in the union election. So what this means is there have not been many public sector strikes in Ohio, even though, again, on paper, it seems to provide a relatively robust strike right, at least by US standards. I mean, in the past decade, there have been about, I think, one public sector strike in the state of Ohio a year, which is, you know, practically Russian levels of striking. Now, Ohio is smaller than Russia, but still, and that is because the fact-finding process is so rigorous. And I guess and I know I'm running out of time, so I will just say, so, you know, what are my thoughts about this? Well, I think you could probably infer them from some of my comments. Obviously, I think that the states that have no collective bargaining rights and no strike rights, I think that's a horrible system where the workers are tremendously disadvantaged. I see no immediate chance of it changing. And in fact, in the last 5 or 6 years, with more conservative controls and more levers of government in the US, we've seen more and more attacks on this, and more attacks on the rights of public sector workers. The rights for public sector workers, for example, in the states of Wisconsin and Iowa have been gutted in the last 5 years. They're much less than they used to be. And we were about to have, oh, by the way, we were about to have a Supreme Court decision which will make every jurisdiction in the U.S. A right to work jurisdiction, meaning you can't have a obligation to pay dues in a collective bargaining contract, which when you have the
Even
Wagner
an
Act,
agency shop.
no agency shop, that is soon coming. If you haven't heard it before, here you've heard it here first. The Janus case, JNUS. This is a result of our previous election and a new Supreme Court justice. But it will soon all be right to work in the public sector, which will hurt public sector unions. Anyway, so there's no prospect of things getting better, I guess is the short version of that. I don't see any realistic chance, and I'm not even sure I would favor the right of, for example, police and firefighters to go on strike. The controlled strike model is intriguing, but that is so unrealistic for the U.S. I'm not going to consider it. So the real question in the U.S. is for employees who are somewhat less essential than police and fire, so, hospital workers, teachers, transport workers. I should have said earlier, and I'm sorry for taking so much time, I should have said earlier, in terms of actual examples of strikes of workers in essential services, you might count the New York City transportation workers strike of 2005, where all the transportation workers went on strike in New York City, and New York City is a city that relies tremendously on public transportation. That was always an illegal strike. New York is a state that makes all strikes by public workers illegal, and that strike was crushed too. So we have not had much success in this area. Anyway, to get back to what I was saying, the most interesting question to me as a policy matter is the intermediate employees, the transportation employees, the hospital workers, the teachers, whether they should at least have binding arbitration, I believe. Should they have strike rights? This is the tough one. It's obviously been the position of labor advocates that strike rights are better than alternatives. In the U.S., it's not clear that that's true. I mean, in the U.S., the strike right has been so eviscerated. I mean, I would be worried that the practice of using permanent replacements, which is now so common in the private sector, would be imported to the public sector, where it's currently not really used in the public sector for public strikes. But public sector workers, I think, somewhat like in Canada, have done all right with arbitration. There's certainly critiques, and Eric walked through some of the critiques, the narcotic effect and all of that, so I won't repeat that here. And I certainly don't think arbitration is a flawless process, but for some of those employees, I think it might be the best you can do. All right, I'll tell you one more anecdote that I should have put in the paper that I didn't, about how sort of strange and arbitrary the distinction between private and public sectors in the U.S., and then I'll shut up and hear what Eric has to say. So after 9/11, the U.S. Nationalized, made federal employees of all of the security agents, the Transportation Safety Administration that some of you may have encountered. Before 2001, these were all private companies. They became federal, and among many other things, these people were denied the rights to strike, and they even had fairly limited collective bargaining rights. So the law establishing the TSA created the possibility to privatize, because of course the people in charge then were keen on privatization. And one airport took them up on it, the Kansas City airport, took them up on it and actually privatized them, and they wanted to unionize into a union covered by the National Labor Relations Act. And the employer made an argument, well, no, the policy under the TSA Act that should have, that bars the TSA from not only striking, but really even bargaining in any effective way, should apply even though they are now technically private workers. And the National Labor Relations Board, even though at that point it was controlled by a majority of Republicans, said no. So just because the same service was privatized, these same employees went from having the employees in these jobs, they weren't literally the same employees, they went from having no strike rights, very limited bargaining rights, to having, at least on paper, fairly robust rights. And that's what a lot of U.S. law is about. So,
Thanks.
Okay, well, first of all, I want to thank Joe both for the quality of the paper and also for not going alphabetically through the state. His life difficult, but also made my life difficult too. it's interesting. I think in many of the same ways that when Joe read my paper and I read his, on some levels it's entirely familiar, and on other levels it's completely alien. So we both, of course, share the Wagner Act model as sort of the basic sort of starting point of modern collective bargaining law in 1935 and 1945, 46. Comes to Canada. The big difference, really, I suppose, in the private sector regime is the replacement worker effect. But and it is a question, right? Of in the absence of the replacement worker provision in Canada, we've also seen a plummeting of strike rates. So it's not clear exactly that is a factor can explain as much of it as I think many people point to. Really, where the terrain becomes completely alien, right, is when we turn away from the private sector to the public sector. And so Joe describes this world, right, in which public sector collective bargaining is barely and not even always tolerated, and where strikes are almost forbidden, right, whereas the world of Canada, as it's developed, is that there are very, very few areas where collective bargaining is not allowed. It's really minuscule. And the no-strike model, and the no-strike model is confined to fairly limited groups of essential service workers, narrowly conceived police, firefighters, and prison guards, right? So, I think in this way, and after listening to sort of so many of the other country reports, it is striking that the U.S. may have arguably one of the world's most, or at least so American exceptionalism stands out once again. And it is a question as to why, and I know Joe spoke, has written more about this, and there's a limit to what he can put in the paper. And you point out in the paper, in your comments, you put a lot of emphasis on the 1919 Boston police strike. But I wonder, if that can, it's hard to know. It just seems, I know in Canada in 1919, there were general strikes. There was a fear of Bolshevism in Canada, and there was a repressive response to that. And in that context, there was a royal commission that looked into police unionism and said absolutely not. So we had that same kind of reaction, right? But it's really in the 1960s, right, when the question of extending collective bargaining rights to the public sector broadly really, I think, gets on the agenda. And I think that's probably true in the United States as well. And so it's kind of a question whether or not that experience of 1919 can explain the politics of the 1960s, and why it was that in the 1960s, when most other countries were expanding collective bargaining rights to the public sector, the United States adopted such a restrictive approach to its expansion. So I'm not sure, I know you've written a lot more about that, and perhaps you might be able to comment a bit more about that. In terms of the specific features, again, what's exceptional is, whereas in most of there's nothing exceptional about prohibiting police and firefighters, from being able to strike. That seems to be fairly common in most of the countries that we've heard about. It's an extension to sort of the public sector, public employees. So, but before I turn to that, I'd be interested to hear, in terms of law in action, a bit more about how, well, particularly police unions, where they do tend to have access to an alternative mechanism, if they've come to, if there's any resistance to this model or as in Canada, they're quite satisfied really with the arbitration model because they've done quite well under it. In that regard, I also wonder where there does exist the option, right, of getting to some form of interest arbitration, whether governments have behaved in the way they've behaved in Canada, where they begin to recognize that those are the results of interest arbitration are fairly generous, right, compared to how at least other workers seem to be doing it. They're trying to ratchet that down in various ways by manipulating or changing the way the arbitration system operates. Really what strikes me as the big sort of almost donut hole, right, in the United States model, and again, not just compared to Canada, but compared to most of the other countries that we've heard about, is the absence of some kind of limited strike for less essential service workers, right? The notion of negotiating, whether it's negotiating essential strike agreements that allow for these partial strikes. And again, that came to Canada in the 60s, gained widespread acceptance. Did that ever get onto the political agenda of the United States, or was it just no strike and there's just no political space to talk about a limited strike kind of model? Because it's just so striking, right? Being in the United States world. And so I guess the last thing in terms of empirical, if there's empirical data, you talk about a variety of alternatives that are provided, whether it's mediation only or fact-finding only, and then various forms of interest arbitration, final offer selection. Is there people done empirical studies to kind of see what the outcomes of those different models are? Because I think that would, sort of, if you can provide some of that in the paper, I think it would, sort of add to our understanding of how the law actually seems to operate in terms of its impact on the employees who are subject to this regime.
If I can just respond for a second. Those were great comments, and I especially appreciate you not mentioning how long the paper was.
Probably no longer than mine.
So yes, just to respond to your points in order, I mean, your paper really makes me wonder about the finding strike rates, because as we both have said, it's often attributed in the U.S. to permanent replacement workers, but it's happened the same way. I mean, look, the U.S. is in many ways a more right-wing country historically, and less sympathetic to union rights historically. We've had some like violent and determinedly anti-union employers in at least the Western world, and that's playing out, I think, with a vengeance now, especially in the public sector, now that people have realized that. I mean, right now the rates, the discrepancy in rates of unionization in the public sector and the private sector are so different. We have a public sector unionization rate of, depending on how you count it, 35 to 40%, and the private sector rate is under 8%, with the result that literally about half of the members of unions in the U.S. are public sectors, even though the private sector is much more vast. It is something to think about. I cannot promise I'll have any good answers to that. But yeah, in terms of, I never meant to suggest that the Boston police strike was the only reason. In the paper and elsewhere, I've argued that the U.S. constitutional system, the federalist system, has placed decision-making about whether public sector workers have rights into very local bodies, so that there could never be, for example, a constitutional decision in the U.S. that public sector employees would have the kind of rights that they do in Canada, because that would be a violation of our 10th Amendment state power and authority. And often the locus of decision-making on union rights has been placed in mayors. I mean, it would be as if, and courts have deferred to the decisions of local officials as to whether they should have bargaining rights. It's as if the court would say, well, let's ask Henry Ford if he thinks unions are a good idea in the UAW. So yeah, I mean, you combine anti-union history. I mean, the anti-union history doesn't explain why it's so much worse in the public sector. I think combine it with your other questions about the donut hole. The objection in the U.S. has not been so. The political objection, the policy objection, has not been so much to public sector workers striking as it has been to public sector workers bargaining at all. There still is a very a number of people have been influenced by a book that was written by Wellington Winter in 1971, The Unions in the Cities.
Union in the cities.
Yeah, Union in the Cities. Still very influential. I was in debates in 2007 when people, or 2011, excuse me, when they were gutting the rights in Wisconsin and other states, when people were quoting Union in the Cities to me. And the basic argument for unions in cities, for those of you who haven't read it, and I can't say I recommend it, but well, if we're going to debate in the U.S., you have to read it because of the policy thing. But the idea that collective bargaining in the public sector should not be permitted because it gives you 2 bites of the apple, and the 2 bites of the apple are, like any other group, unions can lobby for their, goals. But unlike any other group, if you give them collective bargaining rights, they will have special access and special pressure, and you combine that with, and there are some things that that are decisions that properly should be made by the duly elected American, official, as opposed to having to deal with the union. Those arguments are still very powerful, and I think that explains, again, not so much strike rights specifically, and certainly not strike rights for essential employees specifically, but why public sector employees have done so poorly in getting any types of rights. Just 1 or 2 other things. You talked about how the actual parties behave regarding arbitration. I think most essential service employee unions think arbitration is a pretty good deal. Again, traditionally, I think other employees have wanted to strike. But I think now, again, with the decades of experience of how impotent that weapon has been in the private sector, I think more and more, your teachers' unions and your less essential public employees, maintenance workers, for example, think that they may have a pretty good deal. And I can give you one example about the about how employers do it. There's been a big standoff in the state of Illinois, which is another one of the states that provides strike rights to public employees. There's been a big standoff between the Republican governor of Illinois, who's very anti-union, and the AFSCME union, which represents state employees. And the AFSCME union has tried to push through the Illinois state legislature a law that would change their rights from being able to legally strike to having binding interest arbitration. And they pushed it, and the governor vetoed it, and in both cases, they failed to override the veto by 1 vote in the state legislature. But the point is, this is something that's kind of new, and I think shows that a number of public employees now think, with all of its flaws, that arbitration is maybe the better way to go. And as I'm sure you know, there are studies that talk about the efficacy of interest arbitration, and I could talk about them more. They come to mixed conclusions. Yeah, but I can talk about it, and I'll shut up now.
Anyone? I just want to make some, only because I have so much experience with American labor law. What I would like you to add, if you can, to your paper, first of all, I didn't hear anything about the federal employees in the public sector. I don't remember. Secondly, about you have, as I remember, a special legislation about transport employees, which is parallel to the NLRA.
Well, let me ask you, this is what you're thinking about. So there was, in the early 60s, the Mass Transportation Act of 1965, which said if you were in public transportation and you had collective bargaining rights as a private sector employee, if they were transferred into public hands, you had to continue to have?
No, I speak about, I remember the name, but I'll write to you about it. Now, another thing is that I know that over the history, and I think this is very important to bring, because what we want to find out as rich arsenal of intervention as possible in our study. And I remember from the history of labor relations and collective bargaining in the United States that you had years that you used the national emergency procedure, procedures, and this is exactly on essential services. B, you use the presidential seizure in order to cope with strikes in essential services. You know,
So this is
and
what,
I know that you don't use it now, but first of all, there are some empirical studies on the use of it in back in the 60s and the 70s. And I think it's interesting because maybe people can look into it and see whether it was, and also, these are modes of intervention, but as to compensatory measures, for example, I remember from different states that they had something, it's called legislative determination of the collective bargaining agreement as a substitute for arbitration. And I think it's very interesting, to look into the states that do it, just in order to enrich, the alternatives that we are going to have in our comparative study. This is really and I think I want to follow what Eric said, that I think it's important as a law in action study to bring in all, if we can, the empirical work that speak about, that evaluate the performance of all these tools. For example, arbitration and maybe as well as some other, for example, this vote, the ballot about fact finding, I think it's very important. And I think the whole thing, I know for many countries, the whole thing of fact finding is something completely foreign. They've never heard about it, how it's possible, and it's extremely popular in the United States.
I certainly agree about the last point. We may need to talk about the emergency power. The last presidential seizure attempt was by Truman in the 50s, and that was held unconstitutional. The Taft-Hartley Act, which permits presidential commissions to enjoin strikes or lockouts, has been used literally twice. Bush used it in 2002, so that was only the second time it's been used, but I will take
But
that point.
there is this book by Cullen that speaks about 37 cases.
We will have to talk about what you're talking about, because we may mean different things.
Maybe, okay. But we'll
talk.
Okay, we have a short break. We have a short break, and then we have a very, very short session. So please try to be here at 5 minutes after 5, because then we'll have only about 25 minutes for closing.
So do you want to finish at the right time? I don't understand whether to write the law and to postpone the meeting.
No, we have to leave here at the quarter.
Whether to leaving from here, and we agreed to meet
No,
here
but-
at the museum.
First,
something
fascinating. Thank you very much.
Oh, no.
I do. Okay, I thought
Yes,
it was
yes,
more than
You can ask me more. We spoke about
We feel so
getting
fortunate.
Yeah.
Hearing as
Yeah,
well now.
yeah,
Yeah,
Hearing about it.
don't feel that fortunate.
No, we do. Very, very good things are happening here the past few years. We have a renaissance